Hi, I'm Kile Ewing. I'm a former Deputy Assistant Attorney General of the Antitrust Division of the U.S. Department of Justice and a former chair of the ABA section of antitrust law. That section is holding a series of interviews to record an oral history of antitrust practice. At the end of the 19th century, responding to political pressures about monopolies and about a form of business organization called the trust, Congress passed the Sherman Antitrust Act of 1890, followed in 1914 by the Clayton Act. These, by statutory definition, are the antitrust laws. In 1914, the Congress also passed the Federal Trade Commission Act, which, while not an antitrust law, does allow the Commission to define and prohibit unfair methods of competition. It also allows the Commission to set rules for consumer protection. Today we have with us Joel Davidow, who has practiced antitrust law for some 44 years in private practice, at the FTC, and at the Justice Department. He's also taught antitrust law in several major law firms here and abroad, written many articles on the subject, and published a book on international antitrust. Welcome, Joel. We're glad to have you here today.
I'm glad to be here, Kai.
I know that you were born in Trenton, New Jersey back in 1938. You attended public school there and then went on to Princeton University, where you were in the Woodrow Wilson School for Public and International Affairs. And from there you went to Columbia Law School, where you were an international fellow, and also on the Law Review. I understand you wrote a note on administrative reform of the FTC. And then after law school, you went out to Stanford and both taught and studied. And then you began your antitrust career. I'd like to start by asking you, was that FTC note the reason you really got into antitrust law? And did it produce your first job?
Yes and yes, Kai. In order to write the note about the FTC, I went down to interview some people at the FTC, and one of them was Commissioner Philip Ellman, who was a former Harvard Law Review person and a former Assistant Solicitor General who had argued a famous antitrust case, Clores versus Broadway Hale. And to some extent, the note reflected some of his personal views of problems at the FTC, because I was too new to know what the problems were, so I tended to adopt his points. He liked the note and promptly offered me a job, but the draft intervened, and I was told that I had to teach for a year to get to be 26 years old. And at that point, I came to the government and started my antitrust career as one of his legal assistants.
Who were the other assistants at the time of the legendary Phil Ellman?
Well, the dominant assistant, who had already been there a year, was Richard Posner, who already had a reputation. He'd been president of the Harvard Law Review at 21 years old. He'd clerked for Justice Brennan and helped write the Philadelphia Bank decision. There was another assistant, a former Harvard Notes editor, Milton Grossman, who continued generally in the antitrust area. But keeping up with Richard Posner was the goad, or the impossible problem of being one of the assistants.
Did you stay at the FTC for a while, or did you become a staff attorney? What was the next step?
I stayed 2 years in total. For about 9 months, I did things for the commissioner and did some work with Richard Posner. We had the Procter & Gamble Clorox, which is the first of a conglomerate merger cases to go to the Supreme Court. And then I was offered a trial work in what was then called the Merger Division, and they had filed a vertical merger case against the United States Steel Company Cement Division, the defense being that it was a failing company. And one of the two attorneys had left the government, so they said, well, you can go into a 4-week trial in New York and 4 weeks if you do this, and I wanted to try trial work, and so I moved down to the staff, whereupon they took away my parking space in my private office. But I did go and have a long trial against Edgar Barton and other McDonald Flynn of White and Case, so it was an interesting experience in antitrust trial work.
But in 1966, you left the FTC and went over to Justice. How did that come about?
Well, the head of the merger division had been Robert A. Hammond, who is now deceased. He had years ago been on the staff of the Philadelphia bank case with Donald Turner, who then returned to the Harvard faculty. And when Turner became head of the Antitrust Division, he asked Hammond to become his deputy, and a friend of theirs, Lionel Kestenbaum, to set up an evaluation section. Turner wanted there to be a group of people who would bring a certain theoretical consistency to antitrust practice rather than every prosecutor makes up his own theory. And Hammond asked me to come over to the Justice Department and go into this section. And I had had some time with administrative litigation. The Antitrust Division was attractive because it had both civil and criminal powers, and you learned to try cases in the federal courts as opposed to before an agency, so I took the job.
What was one of your first assignments?
They actually used evaluation, since we had what they thought were some bright people, for a mixture of consulting on trials, thinking about policy, and some appeal work. And they asked me if I'd like to do a Supreme Court brief. And I said yes, and it was called United States versus the Arnold Schwinn Bicycle Company. And the general theory was that the Schwinn Company had cut off 5,000 bike shops, and that the reason was that they were price cutters, when there was a whole argument about whether they had dirty windows or whatever. And this had led to a 3-year trial and a gigantic record. And so they brought in 3 file cabinets, and I did a first draft of the Supreme Court brief. And it was then turned over, it happened, to Don Turner and Dick Posner, who had followed me from the commission to justice, except that he was in the elevated position of being a member of the Solicitor General's staff. And they changed at least half of everything I wrote. And then Justice Fortas, in his opinion, changed what they wrote. So the case progressed and we won it. And that victory was reversed 7 years later by a more conservative Supreme Court.
What was another one of your early evaluation section responsibilities? I understand it might have something to do with those guidelines Don Turner put out.
Yes, Don Turner believed at that time that although the government could win a lot of merger cases, sometimes in Vaughn's Grocery with people who only had 6 or 8% of the market, that first of all, it was winning too many, that it was interfering with the economy in ways that weren't justified, and moreover, business people making mergers had no idea of what they could do and couldn't do. So he said we ought to have prosecution guidelines, and we ought to start with the merger area. So we called them the merger guidelines. They were put out in 1968, and the idea was to name that, well, usually in these you create safe harbors to say, well, if you each have less than 20% of the market, then go ahead and merge. We're not going to do anything more. Other such numbers. So a little committee of us wrote drafts, which were edited, and then they came out. Over the years, there was a 1992 set and some further changes. And in general, the safe harbors have gotten bigger. But that was the idea of it.
Well, at that time, in 1968, Phil Neal had a commission that came out with a recommendation that the Antitrust Division be given affirmative power to deconcentrate industry. Indeed, Bill Baxter signed on to that report. That came out at about the same time as the merger guidelines. I take it the merger guidelines of Don Turner didn't go that far.
No, and one of the issues in Neal report and other things of that time was a fear of conglomerate concentration. People like ITT and Ling Temco just buying many different firms, getting very large, and concentrating the economy generally. And I worked on a couple of cases and found that the conglomerate merger theories were going in all directions, and wrote an article called Conglomerate Mergers and the Antitrust Laws, which was published in the Columbia Law Review. And it was fairly conservative, but I, of course, since I was in the division, cleared it with Don Turner. And later, when the division went after another large conglomerate merger, it was actually cited by the Supreme Court against that particular case. So my view, as well as Turner's, was not to go, that the antitrust laws were really not aimed at any general theories of concentration. And I think the division over the years has tried very much to avoid ever becoming a regulatory agency.
I find that interesting because Don Turner, prior to 1968, had in fact made at least one speech and article advocating deconcentration, but obviously he had changed his mind by the time you were working on the merger guidelines.
Well, the other point that happened there is that Don Turner instructed us at one point to look at what were called shared monopolies. And so we looked at the soap industry and the auto industry. And the question is, could you bring a case against 3 or 4 firms that somehow jointly dominated industry, kept fairly constant market shares, no one else went in? At least those were the premises. What we found is that no two industries are alike, and whatever was true of this regard was only true for very brief periods of time. Then somebody became a maverick, somebody new came in, and we basically reported back that this was an impossible task also, which was also a sort of deconcentration. But the same idea came up again later with Bob Pitofsky at the FTC with a serial investigation, and later with Griffin Bell. So the idea that you could police industries or find a way to make them highly deconcentrated was looked at in different ways, but generally rejected when the practicalities and the facts made it impossible.
Well, I understand you were also loaned out of the evaluation section to a trial staff and had some fun with a long case.
Yeah, that was called United States versus American Standard. It was a secret price-fixing meeting involving bathtubs and toilets. This, of course, led to many staff jokes. It's a bathtub conspiracy. Judge, don't let them pull your chain, etc. And but there was a 3-month criminal jury trial involving 11 defendants, and they were all convicted and affirmed in the Third Circuit. And Fortune magazine did a piece. I think one thing I learned in that, there's a theory that price fixing is a sign of greed, and my experience was that it's a sign of fear. That is, the plumbing industry, like the housing industry, had booms and busts or went along with it. And when prices were suddenly falling rapidly and there was oversupply, they started meeting secretly in Florida, and they had a Covington and Burling antitrust guy there to police them, Jim McKay, but they paid their industry director to take McKay out for golf so they could continue the illegal part of the meeting after the legal part of the meeting.
Having known Jim McKay later, I find that very interesting, Joel. But after that trial stint, you left the division for a while.
Yes, I had met a young man, now not so young, in the division named Lee Freeman. And his father, Lee Freeman Jr., was a legendary Chicago plaintiff's antitrust lawyer who had won the Radiant Burner case in the Supreme Court and Kile versus Kasuga. And Lee Freeman Jr. said that he was going out to Chicago to work for his father, and we would bring large cases such as tetracycline drugs, and we would all become rich, rich, rich. So that sounded like fun, and I moved out to Chicago, even though I was warned that Mr. Freeman Sr. was a curmudgeon, and that in any event, the history of small plaintiffs' firms, including the Alioto firm, is that if you were not the son of the founder, you would never have the same rights as the son of the founder, which turned out to be true.
But anyway, I understand you worked on the Gibson case and the children's book case out there?
Yes, the children's book case, resale price maintenance and some cross price maintenance in library editions of children's books went to the Supreme Court as Decker versus Harper and Row. And I was loaned to a private lawyer named Fred Firth, who was beginning what were then called the gypsum wallboard cases, which were price exchange telephone cases. And we worked on the pretrial brief.
But you then returned to the Antitrust Division in 1970. How did that come about?
Well, I hated the Chicago winters. They were much longer and colder than Washington, and Mr. Freeman's idea of how you should get paid was, when I feel like paying you, I will, and when I don't feel like I won't. I generally felt that it wasn't suiting me. And I had had a roommate, Donald Baker, in the evaluation section, and he had risen under the Republican administration, under Dick McLaren, to be a deputy. And he offered me a job if I would return to the Antitrust Division at a higher grade than I left, and I could return to Washington. I asked him, well, what will the Republicans do that I would like? And he said, we're going to deregulate major industries, and I'll put you in what was then called the Public Counsel section, which was a section where we approached other regulatory agencies and preached or tried to persuade them to allow more competition in industries such as airlines, telecommunications, and so on. So that sounded attractive, and I liked Don, and so I told Mr. Freeman goodbye and took my little family and went back to Washington.
I understand you worked on, among others, the Antitrust Division's presentation in the MCI case before the FCC.
Yes, this was the first case to open up long-distance telephone service in the United States to competition, because the new firm, MCI, wanted to come in and offer telephone service between Chicago and St. Louis via microwave towers. And so I urged the FCC to allow them to do it, and it did. But then the states of the United States, called NARUC, National Association of Regulatory Utility Commissioners, challenged the decision because they liked a monopolistic AT&T, which they could force to do public tasks with its monopoly profits. And the Justice Department chose me to defend the FCC decision in the Ninth Circuit appeal, which I did successfully.
I understand you also had something to do with getting rid of Wall Street's fixed commissions.
Yes, Donald Baker was really the champion of both of these. In the telephone business, he had argued Carter Phone, which said that if you had an antique telephone, AT&T had allowed you to have it, which led to there not just being a Western Electric, but lots of telephone makers. And in fixed commissions, Wall Street for 200 years had what became a silly system that if you spend $100 to trade 100 shares, then you spend a $1,000 commission to trade 1,000 shares, and you paid $1 million commission to trade 1,000,000 shares, and everybody had to do it and supposedly couldn't discount, which led to under-the-table kickbacks, because a broker dealing with a big mutual fund could retire on 3 or 4 trades. So, in any event, we entered a private litigation, Thill Securities versus New York Stock Exchange, in which we had famous witnesses like Paul Samuelson testify that it was a dumb system and unjustified, while we also asked the SEC to get rid of it, Congress, and other strategies. And I went through the trial. At the end of it, the judge said he was utterly convinced that it was a stupid system, but he was going to protect them from treble damage liability. And therefore, we didn't win, but around that time, Congress and the SEC got rid of it.
Well, in 1973, you left the Public Counsel, now Regulated Industries section, and became the chief of the Foreign Commerce section. How did that come about?
There was a section of about 11 people. It had had only one chief for, maybe 15, 20 years. His name was Wilbur Fugate, who has a book on antitrust. And it had a very aggressive and excellent lawyer, Carl Schwartz, as the deputy. But in a given couple of months, Carl Schwartz joined a small antitrust firm in town where he prospered, and Wilbur Fugate reached 65 and retired. So you had a section of 9 people, all of whom were young. And therefore they couldn't find a chief or an assistant chief. So my job, they came to me, and Don said that they picked me because I had a background in international affairs at college and law school, and that I was already teaching part-time at that time Catholic and Georgetown Law, and they felt that in international meetings a kind of professorial lecturer would be good at explaining our theories of antitrust. So I agreed to take the job, and somewhat later I had to pick my own deputy. I lured Douglas Rosenthal, who I knew from the International Fellows Program, to leave Fried-Frank and come in as my deputy. And then Don gave me the authority to increase the section from 11 people to 25. So we then were able to run 11 or 12 grand juries.
Well, I know that shortly after you became chief of the Foreign Commerce section, 2 different cases that had been brought by your predecessor became of interest to you. The Diamond case and one other.
Case.
Tell us about those.
Well, under Carl Schwartz, they had run grand juries, and quinine, which was not just for your good gin and tonic, but primarily quinidine heart medicine, a disgruntled employee had written to the Senate Judiciary Committee revealing that there was a cartel, and it had 2 American members, and who pleaded guilty eventually to an indictment, and 2 European members of the cartel, Netherlands Chemical and Beringer, who refused to show up for trial and therefore were viewed as fugitives. What happened in quinine, which was sort of a shock to me, my 3rd day in the new job, the phone rang, and a person said to me, "Joseph Massot has entered the country." And I said, "Who are you? Who's Joseph Massot, and why are you telling me this?" And eventually it became clear that he was a customs official at Kennedy Airport, and that Joseph Massot was the president of Netherlands Chemical and was indicted and was on the fugitive list, and therefore he was on a list which said, if Joseph Massot ever enters the country, call the chief of the Foreign Antitrust Section. So I went up and got an arrest warrant, but we found that he had come in on a Friday, and by Monday he had left. But I thought, well, who knows? Maybe he thinks he's safe. So I had the FBI get his KLM ticket, which said he would spend a week at their cinchona bark plantation, which is what the product from which you make quinine, and that he would be coming back the following weekend. So with the warrant, you now could say to Customs that it's a hold and detain as opposed to a just tell us. And suddenly we got a call saying Joseph Massot is in the West Side Detention Center in New York, and you have just pulled off the first arrest in international antitrust history. So eventually Covington and Burling, your old law firm, and Dan Gribben went up and negotiated a deal that he would plead guilty and pay the fine, but no jail, and we ran it. About 2 years later, the Clary Gottlieb firm came in and said that Beringer would pay, and the explanation was that Beringer now wanted to create an office in the United States and make peace with the Justice Department.
Well, I understand there was something similar to that in the Diamond De Beers situation as well.
Yes, in De Beers, there was an indictment on a worldwide diamond dust, industrial diamond conspiracy. Again, the American parties pleaded. De Beers, South Africa, refused to have anything to do with it. There was a famous affidavit where we tried to serve process, and we're told that the De Beers guard took the American arraignment subpoena or something, ripped it up, said it's no good in South Africa, and threw it at the process server. So we assumed that De Beers was defiant. But then one day, Bob Clare, a senior partner at Sherman and Sterling, asked to see me, came in, and said De Beers would like to plead guilty and pay the fine. But he said they want De Beers Shannon Ireland, which was one of their European subs, to be the one. We would change the indictment to indict De Beers Shannon because for reasons of South African politics of the time, they didn't want to kowtow to American extraterritoriality. So we did the deal with De Beers, Shannon, Ireland, and I asked him, Bob, we couldn't really get you. Why are you doing this? And he said, well, Anglo-American wants the Baron Guy de Rothschild of Paris to be on our board. And he said he will not go on the board until you make peace with the Justice Department, because I don't like being arrested when I shop on Park Avenue at Christmas.
Such is the way
That's
of,
Fifth Avenue, excuse me.
Such is the way of antitrust cases. Let's talk a little bit about the whole international scene. I know that back in 1947, the United States failed to get into the Havana Charter the kind of language about competition policy that we wanted. And that in 1954, Sid Timberg for the State Department didn't have much more success at the United Nations. But during your time as chief of the Foreign Commerce Section, the UN started some rather big projects involving competition policy. Would you tell us about both of them?
Yes, I have an article done in the Stanford Learner, which is called Antitrust at the UN, A Tale of Two Codes. And there's a part of the UN called UNCTAD, which gives special emphasis to developing countries.
And UNCTAD is the United Nations
Commission on Trade and Development.
Right.
And it meets in Geneva, and it's run on sort of a block system. You have a third world block, the Soviet block, and a Western block called Group B, which was essentially the OECD countries, that is Western Europe plus Australia, Japan.
Let's pause for a moment. The OECD had been active, had it not, in the competition area through one of its committees.
Yes, it had a committee on restrictive business practices in which Western countries met 4 times a year, either in plenary sessions with about 22 members or in subcommittee on particular antitrust topics, antitrust intellectual property, where 7 or 8 country delegates would meet.
And that's still going on today, right?
Oh, it's quite successful. It's larger, and it also invites non-OECD members to come and learn from that committee. It's a very serious working committee.
Well, let's return then to the United Nations, also getting involved in the Act of 1975.
Yes, well, the United Nations, the UNCTAD pressed by the developing countries, and I think this arose out of an argument of the ITT scandals in the Chilean elections, had this idea that multinationals did bad things, and of all kinds, including monopolization, and that developing countries should demand that this be corrected. Part of this had to do also with the idea that when you wanted Western technology and you licensed it if you were a developing country, you would have to accept many restrictions on export, restrictions on research, on the use of local materials. And again, they felt that they couldn't stop this, but that developed countries should be pressured to police their multinationals and make them be nicer to small, poor countries that couldn't afford antitrust lawyers. These coalesced into the demand for a set of principles and rules for the control of restrictive business practices and a code of conduct on the transfer of technology, in which the most debatable chapter was a chapter on restrictive licensing practices, where their initial demand was that 40 licensing practices be declared per se illegal. Virtually every restriction you could put in a license.
Making our 9 no-nos of patent licensing look pretty flimsy.
This was an effort to start at the top and go down from there. It turned out that roughly in the restrictive business practice negotiation, I was asked to be what was called the deputy director or speaker of Group B, though my director, a very consensus-building Canadian, didn't like to speak, so in fact I did most of the speaking and negotiating. And in the Transfer Technology Code, I was the Group B negotiator on the chapter that dealt with restrictive licensing. Both negotiations went on roughly from 1974 through around 1980. And in 1980, a set of principles and rules, though of a voluntary nature, emerged from the UNCTAD and was adopted unanimously by the General Assembly. And it did begin with a statement that restrictive business practices can retard the liberalization of world trade, and therefore countries should adopt laws, cooperate with other countries, and such. The State Department informed me, ultimately, though there had been delays and trepidations, that they thought the code was quite all right. And in the transfer of technology, their concept, which was that technology is the common heritage of mankind and no one should encumber it, was so far from the very strong intellectual property bar that we never did reach agreement. The matter was abandoned.
I understand that shortly before it was abandoned, there was a effort to revive it with what was called the group of shadow negotiators. Were you part of that?
Yes, it reminded me of what they did in Oslo with the Israeli-Palestine peace thing. That I was called up by UNCTAD in 1985 when I'd left the government, was a private lawyer with Richard Nixon's old firm Mudrose in New York, and asked whether I would accept 3 days in Geneva at their expense. The idea was they were going to bring back the most progressive ex-delegates around. And in the UN, when codes are done, you have what they call bracketed language. We all agree that it's this, this, and this, and it bracket per se, bracket rule of reason, and so on. So the question is, can you get rid of the brackets? Can you get rid of the things that prevented passage? So I and a Brazilian and an Argentinian and a Yugoslav who'd been educated in the United States, so he was considered the Soviet bloc delegate, but Professor Soltysensky really had pretty much of an American viewpoint. And we did reach a code, but it had no force because made between ex-delegates, except that it was shown to government say, well, we had a shadow negotiation of distinguished experts, and they reached agreement, so why can't you? But they didn't.
They didn't. And that has not been restarted since.
No, I think the screening of investment, which included the screening of codes, has largely been dropped. Most countries have now prefer pretty much open investment, and there are other changes. Countries like India, which was very afraid of multinationals, now have very thriving multinationals of their own. So they're not very interested in the idea of pressuring multinationals to give away technology because their own ox would get gored.
Well, we'll come back to the new version called the International Cooperation Network, or ICN, a little later in this interview, but I want to switch to some of the cases that you brought or participated in as chief of the Foreign Commerce section. And one I remember distinctly was the Arab boycott case. Can you tell us a little about that and President Ford's ultimate use of it?
The Arab League boycott was designed to use their buying power to prevent large companies from doing any business in or with Israel, which they considered an illegitimate state. And so they would try to get promises of various sorts as to what, let's say, American firms would or wouldn't do. And because such promises could be viewed as boycotts, and that is a word that raises possibilities under the antitrust laws, the American Jewish Congress or so went to President Ford and said, would you look into whether American firms are assisting the Arab League boycott? And he assigned the foreign section of the Antitrust Division, or it came down to me. And we looked into it and found that the number one cooperator with Arab boycotts in the United States was the Bechtel Corporation, which for Republicans was a little embarrassing. We ran into political resistance. Normally, if the Attorney General liked the case, that was the end of it. But he was commanded to go to a cabinet meeting where the State Department and Henry Kissinger raised doubts about taking on the Arabs in this way. While they were considering it, a Washington Post reporter called me up and asked me whether on deep background I could confirm that State was trying to scuttle the case, and I said on very deep background I could not deny what he was saying. So anyway, they put a headline in the Washington Post, Justice official reveals that State trying to scuttle Arab boycott case, and Senator Metzenbaum, head of the Judiciary Committee, demanded immediate hearings with Henry Kissinger to testify, and suddenly the State Department decided they guess they didn't really have an objection, and the case went forward. We got a consent decree, but the ultimate step there was that an anti-boycott office and legislation was created, and the Commerce Department enforced a ban on American firms cooperating. The interesting point that I remember also is that during the Carter-Ford debates on the presidential election, Carter said at that time that he was a greater friend of Israel than Ford, and Ford said, well, I unleashed the Antitrust Division and brought the Bechtel case.
There was another famous case that had the State Department quite concerned, called the uranium case. Tell us a little about that, Joel, and how you personally got involved in it.
Well, my job as chief of the foreign section was to look for international cartels, and there were some odd items in the International Herald Tribune about how yellow cake prices were going up and down, partly because the United States was not importing as much as it had, and that there had been meetings in Paris to try to shore up the price of uranium exported yellow cake from countries like Canada and Australia and South Africa, I think. So I wrote to some of these people and said, fellas, would you send me the notes of your meetings in Paris so I could find out whether you're a legal or a cartel, an illegal one or an illegal one? And they all said, mind your own business. And then heavy-hitting diplomats came to me and said, don't ever ask any more questions about that. Clear? Well, I was sort of stymied for the moment. There were no American participants in this stage, though we eventually found out that Gulf Canada, which was part of the American Gulf firm, was involved. Then, to my total surprise, at my apartment door, there was a knock from the mail that somebody had mailed me from Australia a pile of documents about 2 feet high. And I opened them up, and they were every cartel meeting minutes. And I eventually found out that the Mary Kathleen environmental group in Australia had some employees in Broken Hill Mines or wherever the Australian uranium company was, who ran the copy machine all night and then sent this package to me, to California Power Commission, to the Senate Judiciary Committee, and about the New York Times, and so on. So at that point, we had the evidence and we went forward, and eventually the case was pleaded out, and after I left the section, and a long an antitrust case by Westinghouse, which couldn't buy yellow cake, went forward for some years, and there was a $300 or $400 million settlement.
I do remember that from my own days there, because the governments that complained to you at the beginning continued to complain about that case before Judge Preston Marshall. I also remember the fact that when all was said and done, the only person who was jailed because of that uranium cartel was a Canadian government official. And I thought it was rather ironic. This is a little bit out of chronological sequence, but back in 1975, I understand you went on a German Marshall Fund fellowship to Europe. And the reason I'm bringing it up is because it seems to me it also tells something about the relations between the Antitrust Division and the State Department. Can you tell us about your summer over there and the famous lunch and walk in the woods?
The Germans, to pay back for the Marshall Plan, offer money for U.S.-EU cooperation. One part of that is exchange of government officials. So the first exchange in antitrust was that I was to take for the summer of 1975, for about 2.5 months, I was to take the desk of Helmut Stroter, the Director of Policy of the EU Competition Directorate, and he was to take my desk in Washington. So I got an apartment in Brussels, went up and began going to meetings, which were a little difficult because they were half in English and half in French, and I have only high school French. But generally, I was able to follow, though at the time I felt that it was a very fledgling agency that needed a number of changes in direction. I eventually wrote a piece about that with some suggestions, such as a court of first instance and so on. And there was also, but the topic I hadn't thought about, but Willy Schleter, the then head of it, was the question of having a U.S.-EU cooperation agreement, which eventually became a hot topic, resulting in a number of serious agreements in the 1990s, but this was 1975. And so Schleter said, well, why don't you come to my house in Tervuren, which is a very nice neighborhood with a park north of Brussels. And suddenly, I forget just why, but Dean Hinton, the U.S. ambassador to the EU, found out that this lunch was going to take place and insisted that a U.S. State Department, a diplomat, attend the lunch. And then Schleter suggested a walk in the park, and we sort of walked away from the State Department guy, couldn't find us between the trees or something, to say, would I take back the message that he'd like to start a cooperation regime with the Antitrust Division. And there was a nasty note from Hinton saying I was off the reservation to discuss a cooperation agreement without State Department being at my elbow every second.
Nothing came of that complaint, as I understand it, within the Justice Department, though.
Well, the pattern was somewhat similar with the EU in 75, and then I went with John Chenefeld to Japan in 79, and in both cases, the cooperation on an informal level simply grew and grew and grew until it was a fait accompli. It was a fact, and then that was somewhat codified in written agreements later when there was less opposition.
Well, let's return to some of the cases. One that you told me about was the Potash case involving a governor.
Yes, there have now been two Canadian potash cases, one in 79 and another one in around 1990. But potash is a major fertilizer. It's about, U.S. supply comes about 20% from Carlsbad, New Mexico, and 80% imported from the province of Saskatchewan in Canada. And at that time, the largest Canadian producer was actually owned by the government of Saskatchewan, PCA, Potash Corporation, PCS, Potash Corporation of Saskatchewan. Ross Thatcher, the governor of Saskatchewan, felt the prices were too low. He's sort of like a little OPEC himself. So he wanted to raise price, cut supply, and have the companies who did business there guarantee that the Carlsbad producers would follow the lead of the Canadians. And the companies, which had antitrust counsel, said that they didn't think they legally could do that. So Thatcher came up with a theory that he would fly the executives down to Carlsbad, New Mexico, where the governor of New Mexico, David Cargo, would be in one room, and the New Mexico producers would be in the next room, the ante-room. And so a question would be asked, like, can you hold production below X? You know, will you be cutting price below? And they would give the governor estimates. So the governor would leave, come back, and say, well, their estimate is they could do this, their estimate is they could do that. And their belief was that they could state that they hadn't conspired with their rivals. They had merely had a discussion with the governor about his predictions about how things would go in his state. We decided that that was a charade, and eventually there was an indictment. And it was decided for a variety of reasons not to indict the governor of New Mexico. But we did indict the companies, and there was a trial which resulted in, after 7 days, in a hung jury because New Mexico had a fairly serious argument that the supply was so depleted that they couldn't increase production, and therefore rather than it being a production restraint agreement, it was simply a reflection that when they were asked, will you raise production after we lower it? And they said, we can't. So we might like to, but not going to happen.
One of your other cases involved the price fixing of pharmaceutical drugs. And I understand you had an interesting meeting over in Europe in a place that I guess you thought was Switzerland.
Well, I did originally. There was, in those years, a Swiss law that made it a crime to enter Switzerland for an interview or for a Swiss citizen on Swiss soil to give testimony that would aid antitrust. Somehow or other, we learned that an executive of one of the Swiss chemical companies had valuable information and was inclined to cooperate. And so I called and said, could I have an interview? And he says, yes, we'll meet in the Basel airport. And I said, well, I'm not sure that I could safely enter Swiss soil to conduct this interview. And he said, don't worry. It's in Mulhouse, France. I said I didn't understand, but there's actually a line through the airport where the French border is. So if you're behind the coffee bar, you're in France, and if you're in front of the coffee bar, you're in Switzerland. So I flew into the airport, and I saw the right person, and I said, you come over here. Had he crossed the little yellow line in the airport, so we're standing in France, and we had the interview.
You ended up closing that case
I think
successfully.
Unfortunately, that the reason he was so cooperative is that he knew things that would show that my case wouldn't win.
Tell us a little about the first Tunney Act case where a judge refused to go along with the government's consent decree.
I know. This was the wheelchair case, the Everest and Jennings wheelchair case. And again, I was trying to be aggressive and look for cases in the newspaper, and there was a column in the paper which said that it was terrible that the Everest and Jennings company sold wheelchairs for $500 to poor American disabled veterans, but you could buy them the same wheelchair in London for $300. So why were they, and why weren't people allowed to buy the $300 wheelchairs instead of the $500 wheelchairs? So I was in London for a meeting with British Antitrust and went into an Everest and Jennings store and said I was Dr. Davidow, a orthopedist, and I'd like to buy some of these chairs. They said, oh, we're not allowed to sell in the United States. It happened that Everest and Jennings Europe was only 50% owned by Everest and Jennings, and at that time you could make an argument that it was a conspiracy between a company that's not 51% owned is a separate company. And so we brought a case for monopolization and conspiracy against Everest and Jennings, and after a while they signed a consent decree saying that they would no longer in any way impede their foreign suppliers from selling to U.S. buyers. So we signed the consent decree and went to court to have it approved as being in the public interest. But the paralyzed veterans of America wheeled into the court in their wheelchairs and said that this was a sellout. It was too weak. And the judge pressed Everest and Jennings, and they finally changed the decree that they would pay bonuses to their foreign subsidiaries for making U.S. sales. And the decree, as altered, was signed.
Well, in December 1977, you left being chief of the Foreign Commerce Section and became director of policy planning, but you continued to have responsibilities for both the bilateral and multilateral international work. That allowed you to cover a whole range of philosophical issues, and so I'd like to ask some of your general thoughts about antitrust theories and philosophies over time. You were sort of there at the opening of the Turner Guidelines of 1968. You helped draft them. What was the reception to those guidelines? Did anybody in the division still believe Joe Bain's concentration theses at that point?
I think the reaction of most people in the Antitrust Division wasn't that theoretical. Their view was that if you had something that looked like a good case, it was up to the other side to make the arguments against it and not have your own boss in the division tell you what you couldn't argue if you thought you might be able to win it. So I don't remember a lot of debate in that point, and there was an oddity, which is that when the Republicans, the more supposedly conservative party, took over from the Democrats under Rick McLaren, he was fascinated with ITT and conglomerate mergers, and at one point, Harold Janine went to Richard Nixon and said, "You're Republicans, you've got crazier anti-merger theories than the Democrats had." And eventually Nixon told, McLaren lost all those cases in the district court, and eventually it became known that nobody favored taking them to the Supreme Court, and the losses were absorbed, and merger policy became more conservative.
I understand a newspaper reporter about that time called you on a background basis and asked your view about the decision not to go up to the Supreme Court.
Well, I'm a lifetime rabid Democrat, and I suppose I would have liked to say bad things about the administration, and there was some argument that ITT was a corrupting influence because it gave free Sheraton hotel rooms for some delegates to the San Diego Republican Convention, but they called up and said, is this a sellout, the dropping of these cases? And I gave an honest answer. I said, no, there really is no good theory under the antitrust laws to prevent ITT from buying Hertz Rent-A-Car. It was one of the cases. They're just apples and oranges, and they don't add up to concentration that means anything. So I think it was simply sensible law enforcement, and I don't see that you needed any politics to reach that result.
Well, during your time with the division, what were the cases that you worked on that were, in your mind, the most important, at least in the long run?
Well, in a way, the deregulation, certainly the opening up of the telephone business. I did a little bit of work on opening up the airline business. I argued a case about whether the CAB could stop people from using 5 wide seats instead of 6 narrow ones. So in a way, when you win a cartel case or bring one, it's only one in a whole string of cases. And in itself, it has a certain deterrent effect. You legitimize some ideas. I do think that as we kept going and teaching about what we were doing and teaching why cartels were really unacceptable, there was this gradual trend from 20 countries having antitrust law to 30 to 100. So I think that aggressive anti-cartel enforcement combined with teaching abroad of why we were doing it and why it made sense had an influence. I don't think it was any one case that did it.
What about the Supreme Court cases? What cases would you consider to be the most important that the Supreme Court has decided since, say, Brown Shoe?
Well, with very rare exception, Supreme Court cases since then have dealt either with the delicate relationship between governments and the antitrust laws, or with cases that the division either shouldn't win or should have difficulty winning. So that they're important, I suppose, in creating an antitrust law that's sensible, that the treatment of vertical distribution in the Continental TV Sylvania case was a very important case in that it began a trend to leave vertical distribution to very rare cases where the antitrust laws would intervene. The recent Epigram case, which says that international cartels in other countries can't be tried under U.S. law, is important because the issue was developing very rapidly, where after the vitamin cartel case, people tried to do that, but I don't. I think it was some line drawing as to, well, you'll have to do this some other way if you want to have multinational antitrust enforcement or multinational cartel compensation of victims. You can't just bring everyone into an American courtroom without changing the law.
What about Hartford Fire and the Illinois coal case?
Well, Hartford Fire, which dealt with whether we could go after British reinsurers for agreeing not to offer any coverage for certain kind of environmental risks, was an important reaffirmation of an earlier case, Continental Oil, in the Alcoa case, that the United States could apply its law to foreigners meeting abroad as long as it was clearly aimed at the United States. I was, in my mind, always mildly horrified by Judge Scalia's dissent on that case, suggesting that we couldn't, which I thought would have been an enormous setback for antitrust enforcement. And it was a 5-4 vote. Had it been a 5-4 the other way, I think that the extraterritorial application of U.S. antitrust laws would have been greatly injured. So I thought that was a very important decision in what it didn't do.
Well, Illinois Coal, I guess, was the first merger case the government lost after.
It was called General Dynamics,
yeah.
And it was a case where the market shares were high enough for the government to win, but the court, in a majority view, said that since it's predictive statute, you have to look at the industry not on a market share at a given day, but where it's going. And somewhat like my potash case, in Illinois Coal, one of the parties was running out of coal. And they said, well, yes, I have 30% of the market, but next year we're going to have 28, 26, 24, because I don't have any more coal. And therefore, it's silly to say if you have 30 and I have 30, it's illegal. You have to look at what's the real competitive impact of the merger, and the answer was not much, because one of the companies is a sick puppy, and that's where it is.
Let me ask a hard question here. You've worked in both the FTC and the Antitrust Division. Do you think that it's a wise idea to have two antitrust agencies at the federal level?
Only if they could avoid overlap. I would think it makes no sense to have any two agencies, not that they not be in the same general subject matter, but to have a direct category of cases that either one can bring and that you just have to divvy up. The FTC can investigate industries, set rules, make recommendations to the Justice Department, but in the area of actual cases against an antitrust violation, particularly a merger, rarely a cartel question, having two agencies, no other government has ever done it that way. In Japan, there is an FTC and a Ministry of Justice, and if it's civil, they bring it, and if it's criminal, they refer it to justice, and they know who does what. And in mergers, we just stumble along, and so that ought to be corrected. When they've tried to correct it informally, various people have jumped on them. So in a perfect world, I would avoid at least the direct overlap. No category of cases that can actually be brought by both agencies.
What about the overlap between the federal agencies and state attorneys general? Well, and the further overlap with the private enforcers.
Well, I think even in Germany, for instance, they have national antitrust and they have antitrust in what they call the Lands, the states. And to the extent that, there is price fixing among the restaurants in Houston, it seems perfectly sensible for me for the Texas Attorney General to go after it instead of the Antitrust Division, which ought to be going after bigger interstate matters. So I think that if everybody doesn't get too ambitious, it's probably all right to have state antitrust. And I think that private antitrust has always been part of our American democracy, that private people who, if I'm a Democrat and the Republicans won't bring a case, and I say, well, hell, I'll bring my own case. Then that's America. To me, that's let the people do what they do.
Let's turn to joint dominance, a concept that the Europeans have, and we used to call, I think, shared monopoly, which you've spoken about. Do you think that, well, do you agree with the European Commission that three or more firms can actually possess joint dominance in the sense that the three can extract super competitive rents?
Well, I don't know the question whether they can. The question is, does it lend itself to an antitrust enforcement solution? I mean, and my general view is no, that we tried it here, and telling people don't be jointly dominant, don't imitate each other, it's like telling them not to breathe. You can't police. If I read that my rival is offering a new service or is raising or lowering price and I decide to ape him, the answer is, it can't have a government official telling me either you must or you mustn't. That just doesn't, to me, it's just an unenforceable idea that there may be a given practice that one of them is doing. That, for instance, we used to have a thing called facilitating practices, like three dominant firms agree that they will never have a price sign over 20 feet high, or every customer will have to buy by rail and not by truck, because it's easier to follow your competitor if you know what his prices are. We've done some of that in our trade association cases, where we are not going to allow an exchange of information so detailed and so current that people can pursue joint dominance by knowing exactly how many discounts the rival's giving, so they know how many to match. So I would continue to go against facilitating devices, but not against joint dominance or simple imitation of each other.
Joel, you've had a long and distinguished career in antitrust with the government, and now for the last few years in private practice, and I know you've continued to be very active in looking at what's happening in the world. And indeed, I think you're about to teach at one of our more distinguished universities in the area of international antitrust once again. What is your view of the work of the ICN? Do you think that's useful in carrying on the more rational approach to antitrust around the world?
Well, I'm starting the first course at Johns Hopkins School of Advanced International Study on the World Competition Regime, and I've been looking at the papers produced by this International Competition Network. And I think it's a marvelous way of moving forward. There was a thought of having a binding antitrust code under the WTO, and that so far is postponed because people don't like world law very much. But instead, here you have 70 or more antitrust agencies constantly exchanging emails and occasionally meeting and creating committees. And the whole purpose is to learn from each other and ultimately to harmonize. And since we have a world economy, it makes sense to have world rules of competition and to expect that when you are in different countries, if you're dealing with an antitrust division, just as if you're dealing with an environmental agency, that they somehow or other understand the same concepts and will treat you in a way that makes economic sense and is also procedurally open and fair. So I think what the ICN is doing without compulsion is exactly what ought to be done, and it's getting done much better that way than it would be to try to create a world law at this time.
I understand that the number of agencies now participating exceeds 100, so it seems to be succeeding, Joel, and I know you had a lot to do with starting it all. Let me ask one final question. What advice would you give to a young law student about whether to go into the field of antitrust law and how to do it?
Well, I would certainly say yes, that at this point, a combination of law, policy, economics, and international relations is nearly unmatched as a challenging field of law, generally well compensated if you're on the private side of it. It is somewhat dominated, at least on the advice and defense side, by very large firms who are very selective. So it's obviously not a field everyone can choose to be in. Some people polish their language and economic skills as well as their legal skills, which can be helpful. I notice now that China has just passed an antitrust law, and so yet another field where if you have something which we didn't used to think was important, like Chinese language skills, you're likely to get a job a little more quickly. So that would be my advice. There was a second half to your question besides the advice about whether to go in or how to do it. Well, I think I get good grades, interview well. Those are also relatively important.
Joel, this has been a fascinating interview. We thank you very, very much, and we wish you well as you continue in private practice to practice antitrust law. Thanks, Joel.
Thank you for inviting me and letting me reminisce about all these things that have happened in my life.